Now we got $1 million that we're going to divide up between the kids. And the question is, are these kids really ready to receive $500,000 apiece? Big issue on clients' minds are whether or not their children are ready to receive or mature enough to receive that kind of found money. And the big specific issues that they're concerned with are the kids might get divorced. Divorce rate in this country is about 1 in 2, so it's a very legitimate concern that parents have. Opportunists, snake oil salesmen that may come take advantage of their kids, trick them out of their money, have them make foolish investments and such. Or lawsuits. They get sued because they ran the wrong stop sign. They get sued because of a bad business deal. They get sued because there's a tax lien out there, and now they got money, and so that tax lien, the IRS is coming after those funds. All very realistic concerns, all concerns that most of the parents that we talk to have, concerns that frankly most of them haven't done any preparation for. Yes?
So Ralph's out of the picture. He's out of the prenup.
He's out of the picture, yeah. They didn't actually go through with the marriage. So, yeah. I didn't want to make it too complicated. So we think Susan's ready to receive, mature enough to receive her inheritance, but we haven't talked much about her lazy, no-good husband, Jason, right? Who, unbeknownst to Susan, 6 months from now is planning to get a divorce. Susan receives her $500,000, puts it in joint brokerage accounts, joint bank accounts. When that divorce is filed 6 months later, we call those joint accounts marital property. And the job of a judge in a divorce is to divide marital property equitably between divorcing spouses. And so equitable division of marital property means pretty much whatever the judge says it means. So we stand a real risk of some, maybe even half of Susan's inheritance getting lost because it got commingled with these family assets by virtue of this poor planning. Now, luckily John's not married. We're not worried about John's wife taking anything because he doesn't have spouse, but he's had other issues. He's got creditors out there. He's likely to incur new creditors. He's probably going to have a really fast car and a lot of friends at the funeral and not much to show for things 2 or 3 years later because John's kind of made bad decisions over the course of his life. And so that's kind of the nature of this will-based plan that didn't really take into account these various options that are out there. An alternative to this is this revocable living trust, this concept of we create this box, Bill and Mary transfer assets into the box so that now they are controlling the assets as trustees, not as owners. And so as a result of that, we're able to avoid a lot of these things. They serve in all 3 positions, trustor, trustee, and beneficiary. And so it's business as usual for them. They're going to still get homestead exemption. They're still going to be entitled to tax-free gain on sale of residence if they sell their house and move to a different house. They're not going to pay tax on that gain up to $500,000 between the 2 of them. The kids are still going to get stepped-up basis on the property. We're not giving any of those things up. But the trust just serves as a standby device to be able to avoid probate and avoid that conservatorship possibility. And the reason we're able to do that is because title to the asset doesn't change during these different stages. Remember, probate is designed to transfer assets from deceased people to living people. If it's owned by the trust, as people die, it's still owned by the trust. So there's no transfer, there's no court involvement, so we're able to avoid that process. So Bill and Mary are alive, they're co-trustees. Bill dies, Mary's sole trustee, sole beneficiary. Mary dies, Susan's trustee, John and Susan are beneficiaries. Trust is owner throughout all of that. And so no change in ownership, no requirement to go through the probate process. Yes, Ed?
Well, if you have a husband and wife, and the husband works and has got, say, $100,000 in 401k, and they get a divorce. In a community property state, I think it'd be half and half. But in Mississippi, what happens?
It's part of equitable division. So the court can enter what's called a QDRO order, Qualified Domestic Relations Order, that divides that account between the husband and wife, and that's just part of what the court considers. So the fact that it's titled in husband's name doesn't have anything to do with the court's ability to move that from husband to wife's share. And it's not going to trigger tax because he does it through an order that says that this portion over here goes to wife into her IRA without triggering the tax. We still get the tax deferral on that. But that's part of that. That's going to be considered marital property, even though it's separately titled, because it was earned during the marriage. And presumably, he was able to build up so much in his because we were spending hers. And so it wouldn't really be fair to say, well, she didn't have didn't have a retirement account, but he does because he was able not to have to spend as much. Yeah, I mean, generally speaking, that's what we generally see in a long-term marriage. Now, if there were already assets there when they married and things like that, the court may put more over here and that sort of thing. But that's kind of what the court's doing, is weighing assets and weighing alimony. And so if there's going to be alimony, there may be less shifting of assets because we've got this ongoing payment going over. And so it's a complicated area of law. I don't practice domestic relations, by the way. So don't call me about your client's divorces. I can't help there. But that's kind of what goes on in that process. So Bill has his stroke. But we don't have to go through conservatorship. Mary can sell the house as sole trustee of the trust because the house is owned by the trust. We're to sell the house, sign the deed, get a check, and no court involvement in that, none of the delays. 6 months later when Bill dies, we don't have to go through probate to get assets moved to Mary's name. They're in trust. Mary's now trustee of the trust, and we don't have to worry about any shift of assets. And so it's a very, very streamlined process, very fast process. Now what happens afterwards? Well, a number of things can happen afterwards. We can leave the assets in trust and Mary's sole trustee. It's called a survivor's trust. And she could be, continue on as the sole trustee, sole beneficiary, and have rights to revoke it and such. Doing that doesn't provide any protections, though, against these issues that we've talked about. So a second option is we could divide those assets between a survivor's share and a marital or family share of the trust. So we're able to move some of the assets over to an irrevocable trust at death, really to get some of the controls and some of the protections over them that may protect us from third-party creditors, may protect us from remarriage issues, and may even protect us from nursing home, loss of assets to nursing home. If we do that, and by the way, that was what we commonly did when we had taxable estates. We were doing that, shifting assets to use the exemption of the first spouse to die, but still have enough control and enough benefit for the surviving spouse so they still felt like the assets were theirs and they got the benefit and use of them. We can still do that today. We're doing it for different reasons, though. The one bad thing about having a large estate tax exemption number is that low estate tax exemption number got people in the door. And I don't mean got people in the door so I could make more money. I mean got people in the door because they didn't realize the planning that they actually need. They came in thinking they needed to save taxes. And they probably, a lot of times they did. But the real planning that they needed was to protect against remarriage, to protect against, for the kids, protect for Medicaid or to get double step-up in basis or a number of other things that we might want to do and can accomplish in planning that they didn't realize were goals of theirs or realize that were things that they were needing to accomplish. They just knew, when I die, I don't want to have to pay taxes. With the exemption so high, they're not rushing in the door worrying about those taxes now. And so it becomes more impendent on us as advisors to explain to them, as we're talking to our clients, the benefits that they nonetheless can receive from doing good planning that have nothing to do with taxes. Like I said before, they understood that and kind of came in the door on their own. We were able to explain it to them. If we divide the assets into these two shares, though, this family share and this survivor share, now when Ralph comes calling, we're not necessarily worried about losing these assets or losing a large amount of these assets because of this remarriage, right? The assets over in the family trust, that's an irrevocable trust that Ralph is not a beneficiary of, can't ever become a beneficiary of. We can even have provisions in there that cut Mary off if she remarries unless she gets Ralph to sign a prenuptial agreement, which is frequently what we will do. Not because we want to keep Mary from remarrying. Sometimes we have that, but not usually. What we want is an excuse for Mary to ask what otherwise might be a very awkward question, and that is, hey, will you sign a prenuptial agreement? So that we can make clear that they're marrying for love, not for money. It gives us the ability to do that, and if she doesn't, she gets cut off perhaps, or there's a second trustee that steps in, like the kids perhaps, or some other consequence that helps protect the kids' inheritance by virtue of not following through and getting that prenuptial agreement signed. And so we're able to do that in a trust like this, whereas if it just goes outright to her, we don't have those incentives and those controls to be able to put in place. We can protect against that. Additionally, the assets in the trust are not subject to those marital claims. Those claims that I told you about are claims that are made in the probate estate. They're a right to elect against a will. Well, we don't have a will to elect against here. We got assets in a trust. And so we got solid case law on the irrevocable trust not being subject to those rights of election. And we feel pretty confident that assets in a non-irrevocable trust that are in the revocable trust in the marital share would also not be subject to that because they don't fit the definition of how someone exercises those rights. Now, I say we have confidence of that. We don't have a court case on it yet. Eventually, someone will file a lawsuit on that issue, but so far we've not had that in Mississippi, and so we're really dealing with an interpretation of law that's by us lawyers and not by the court. But at any rate, we've got at a minimum half the assets protected if we divide those between that A share and that B share, and a good argument that all of them are protected and not subject to these marital claims. The house is in the trust, not going to be subject to that right to live there. The right of the child share is again an election right in the will, but there's not a will. We don't have a probate estate. And so we think we can avoid these things by virtue of that. Same thing with liability protection. Liability protection, the assets that went over in the family share of the trust, that's the irrevocable share of the trust, are not going to be subject to claims of creditors, because that's going to be a support trust. It's going to be a trust that's designed for Mary's support, education, her health perhaps, not to pay her creditors. And so that's not a support obligation. They're not a beneficiary of it. She won't have the right to appoint them as beneficiary of it. Therefore, those assets are protected from those third-party creditors. The assets that are over on the left side, though, the assets that are over on this revocable side, the survivor share of the trust, she's still in charge of those assets. She has the right to amend that trust. She has the right to say where they go. If that's the case, then a creditor also has the rights to claim those assets. Just because the assets are in a trust doesn't automatically make them unavailable to creditors. It's the fact that the trust is irrevocable and the trust is not subject to creditor claims that makes it not available to creditor claims. And so her share of the trust, on this A share over here, it's still revocable. She could do whatever she wants to with it, including pay her creditors. Therefore, a creditor could force her to pay them if they wanted to. So in that case, we only protected half the assets in this planning with respect to that creditor. Nursing home care depends again on how we structure things, but we can structure assets in a trust, in an irrevocable trust, that make them not available for paying for Medicaid, or paying for nursing home care, rather. Not subject to being counted by Medicaid if we plan ahead for that. Same thing with who's going to be in charge. We're going to name Susan in charge. We're not going to give John the ability to be in charge, and so he's not going to have any forum to step forward and seek to be appointed. Yes?
How far do you have to plan in advance to do what you just said about keeping it out?
Depends on how we're doing the planning. If we're doing death planning, we don't have to, before they die, I guess. But there's not a 5-year look back or anything for that type of transfer. If we're doing lifetime planning, and we'll talk more about it in the latter part of the day, if we're doing lifetime planning, 5 years to get maximum protection. Okay, and so there's a 60-month look back, and the way that works is Medicaid looks backwards. If you apply for Medicaid, Medicaid looks backwards 60 months and says, you made any transfers in the last 60 months. If you had, we're going to penalize you for the value of those transfers and make you ineligible for Medicaid for some period of time. It doesn't mean that it's all or nothing. I transferred the assets, only made it 4 years, therefore I'm never going to be eligible for Medicaid. It's not that at all. There's a consequence. We're going to save less money if we only make it 4 of the 5 years. But we're still going to save more than if we didn't make a transfer at all. And so I have a lot of clients that we're not sure they're going to make it 5 years, but they're still better off doing the transfer than not doing the transfer, even if they make it 3 of the 5 or even 2 of the 5.
Is transfer the same thing as you stating about putting it in a trust?
Yes, yeah. I mean, our goal for Medicaid is transfer the assets out of your name somewhere else, because Medicaid penalizes that if it's done within 5 years. And so somewhere else usually winds up being a trust, because if you look at all the other alternatives, the trust is the best alternative. For tax purposes, for control purposes, for protection and for the comfort of the kids. Frankly, they all, it's more advantageous for them as well. Usually doing it that way. So now Susan's in charge. She's able to manage the assets. If we've done good pre-planning right for Medicaid protection and have the right types of assets in right trust, we may get immediate qualification, or we may get qualification much faster, and we don't have to go through the probate processes and the conservative processes. When Mary dies, we don't have to go through probate. We're able to avoid that and have those assets then transfer to the kids. And so that's kind of where a revocable trust will come into play, and how it can come into play even post-death to provide protection for those spouses. Now, we still have the issue of the kids ready to receive $500,000 apiece, right? Still concerned about opportunists and lawsuits and divorce. And so some of the different options that we've got for leaving assets to the kids, we can leave it outright. That's kind of our client's default, right? They assume that they're going to leave everything outright to the kids. Or we could leave it to the kids in trust. And there are a lot of different reasons we leave assets to kids in trust. One of the reasons is because the kids are irresponsible and we need someone else to be in charge of their money, right? But a lot of parents, oh no, I can't do that to my child, even though they're, if they just blow it, they blow it type thing. And so those clients will be inclined to go ahead and leave it to them outright. A second way to leave it to them in trust, though, is a trust that's very easy for them to access themselves, a trust that they themselves can be in charge of. I analogize this type of trust to like a tube of toothpaste. We're all familiar with toothpaste. You squeeze, if you want some toothpaste out, you take the top off, you squeeze it, toothpaste comes out, put the top back on, it's protected. Nothing gets in, nothing gets out. We can design a trust the same way. We can make it very easy for the kids to get money out if they need it, but otherwise lock it up where third parties can't get it. Third parties like a divorcing spouse, third parties like a third-party creditor, third parties like the IRS or a business debt. And so we can design that trust so that it's protected for the child, even though they've got control over it, even though they're getting the benefit from it. We have a couple different types of trust like that. One's called a family Sentry trust. Family Sentry trust is a trust that a third party basically stands guard or stands sentry over that makes it a little bit harder to get those assets out. That's the kind of the trust that we put in place for John. John shouldn't be in charge of his own money. He's going to squander it. The fact that we've protected it from creditors is not going to do him any good because he's going to likely spend it on foolishly on the wrong things. A family access trust is a trust, though, that Susan would be totally in charge of, even though Susan is the beneficiary. Susan can control how that money is invested. She can control when and how it gets distributed out. Third parties, like Jason, when he divorces, are not going to be entitled to those assets because they aren't owned by Susan. We're able to give her creditor protection and divorce protection over those assets because of the way the trust is drafted. So it's, I think, a superior way of leaving assets to the kids than leaving it to them outright. So now when Jason files for divorce 6 months later, this $700,000 that's in Susan's trust is not going to be part of a marital division of property. It was never commingled. It wasn't even owned by Susan. Certainly couldn't be jointly owned by them. It's owned by a trust that she didn't even set up. Mom and Dad set that up. She's just a trustee of the trust, and she's a beneficiary of the trust, but it's not subject to that marital division of property.
So when he finds out, he said, "Oh, I was just kidding."
That's right. That's exactly right. So but Susan still has the control that she needs over the assets, and so we're able to protect that inheritance for her. John, when he gets sued or something like that, his assets are not going to be subject to his creditor claims either, and they're not going to be subject to him just withdrawing it and spending it. He's got to pass through Susan, or pass through an uncle, or pass through a third-party trustee that has discretion over distributing those assets or not. So we're giving him protection both from third parties as well as protection from himself. We could even build in incentives in a trust like that if we wanted to. So if we wanted to incentivize John finishing school or buying a house or pulling a job down or whatever conduct that we want to incentivize, we can design the trust in that way. So maybe it's a trust that matches his own income up to a certain amount or something like that. Maybe John's problem is more than just bad judgment. Maybe he has bipolar disorder. Maybe he's schizophrenic. Maybe he's getting public benefits or qualifies for public benefits. An inheritance of as small as $2,000 will kick him off of those benefits frequently. And so we could design a trust for John where it's a supplemental trust that can't be counted for these public benefits, but it could supplement the care that John, the benefits that John receives. And so those are all options that we've got with respect to
what kind of income? What kind of supplemental income? I mean, let's say if he got $500,000, you would put that in a trust and set up.
Yeah, if he's getting means-tested public benefits, let's say he's on SSI for some reason and on Medicaid, that $500,000 is going to kick him off instantly. If we throw it to a supplemental needs trust for him, it's there to pay for extra things, but he's still getting Medicaid. He's still getting his SSI check.
Does he have access to it, or is that a trust?
We'll have a trustee in that case. We got to have a third-party trustee if we're going to do that. But that trustee can pay for trips. That trustee can pay for him to live in a safer part of town. That trustee can pay for things that can make his life more comfortable, clothes, basically anything but food and shelter. It pays for food and shelter, we're going to reduce his benefits down. But other than that, we can pay for entertainment, we can pay for stereo equipment and video games and things of that nature to make his, to improve his quality of life, and yet we're not blowing it all on medical expense because he still qualifies for Medicaid in that circumstance.